The hour of 9 has been reached. Good morning. John Bolger is my name. I would like to advise our guests that Commissioner Caulfield and Commissioner Bergen are participating by phone. Commissioner Caulfield, Commissioner Bergen, we have a lot of guests today. I just wanted to point that out to you.
Thank you.
Thank you.
Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting was held on February 6, 2014 to review matters that are by statute 65 PA CS 708-1108 confidential, including the review of completed investigations for purposes of issuing final adjudications, the review of a confidential opinion request, the reconsideration of a confidential opinion, the review of an appeal of a confidential advice, the review and consideration of applications for 90-day extensions of investigations filed by the Investigative Division, and the review of pending legislation. An executive teleconference meeting was held on December 3rd, 2013 to review matters that are by statute 65 PACS 1108 confidential, including the review and consideration of an application for a 90-day extension of an investigation filed by the Investigative Division, and the review of a preliminary closing. An executive teleconference meeting was held on November 26, 2013 to review matters that are by statute 65 PACS 708 confidential, including a request for consideration of a confidential opinion. 2 executive quasi-judicial meetings were held on October 9th to conduct quasi-judicial deliberations as to the review of a public lobbying opinion and the review of a public ethics commission. That concludes the statement that I'm prior to read till we open the meeting. First item on the agenda this morning is approval of the October 9th minutes. Do I have a motion to approve those? Is this the same? We don't have Martin Harder, who was in attendance from the staff. I would entertain a motion that we adopt these minutes with the inclusion of Martin Harder on the staff. Second by Commissioner Nick. Any comments or questions? Okay, all those in favor say aye.
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 Any opposed? Minutes have been adopted. Second item on the agenda is Senate Majority Leader Pileggi. The way we work is different commissioners are assigned different cases. And in this case, Judge Lewis has been assigned this case, and she will proceed from here.
Good morning. The requester in this matter is Mr. Dominic Pileggi, a Pennsylvania State Senator and the Senate Majority Leader. The questions presented for the Commission's consideration pertain to proposed postings of legislative material and campaign-related material on the Senator's Facebook page, which is a non-governmental Facebook page. Senator Pileggi states that Facebook is a widely used social media website, and many constituents expect legislators to communicate via Facebook. Creating and maintaining a Facebook page is free, unless a specific choice is made to pay for advertising. It is represented that individuals using Facebook may choose to, quote, like, close quote, a Facebook page established by or on behalf of the senator, on behalf of a legislator. This allows posts made by the legislator or made on the legislator's behalf and possibly in the name of the legislator to be seen on the legislator's Facebook news feed. In some cases, depending upon settings chosen by the legislator or on the legislator's behalf, such posts can be viewed by individuals whether or not they, quote, like, end quote, the page. Posts on the Facebook page of a legislator can be made on behalf of that legislator by anyone with access to the necessary login information. Such posts can be made from any connected device such as a desktop computer, laptop computer, tablet, smartphone, and the like. Senator Pileggi poses the following specific questions. Assuming that absolutely no state resources would be used, is it a violation of the Ethics Act for a legislator to permit an individual who is not a legislative employee to post legislative material on the legislator's Facebook page on behalf of that legislator? Assuming that absolutely no state resources are used, is it a violation of the Ethics Act for a legislator to permit a member of that legislator's campaign staff or an officer on that legislator's campaign committee to post either campaign-related material or legislative material on the legislator's Facebook page on behalf of that legislator? Assuming that absolutely no state resources are used, is it a violation of the Ethics Act for a legislator to post campaign-related material on that legislator's Facebook page on his or her own behalf? Assuming that absolutely no state resources are used, is it a violation of the Ethics Act for a legislator's campaign committee to pay for advertising to promote a Facebook post made to that legislator's Facebook page? Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
Thank you. Thank you, Mr. Aronson.
Thank you, Mr. Chairman, Your Honor, Commissioners. My name is Eric Arneson, Communications and Policy Director for Senate Majority Leader Dominic Pileggi.
Thank you. Did you get that, Heather?
Yes, I did.
Thank you. May I proceed?
Yes, sir.
I'll be very quick here, and obviously at the end, I'd be very happy to answer any questions for the Commission. As indicated in Senator Pileggi's letter, signing up for Facebook is entirely free. It may or may not be done on a legislative computer. Legislators use Facebook widely. At least 31 senators and 133 representatives are on Facebook now. And in terms of liking the pages, each like represents a different unique user who can see the posts made by or on behalf of legislators. As an example, right now Senator Pileggi has a little over 1,500 individuals who have liked his Facebook page. Facebook allows users to, the individuals who create pages for the legislator, whether it is the legislator or in the case of Senator Pileggi, I did this, to establish administrative roles which determine who can post. And there are 5 different categories of those people. And they can be anyone who is given access by, in this case me, the person who created the page. So I wanted the Commission to know that it is possible for there to be multiple people. In our case, there's 2 showing here. I think we actually have 4 different individuals who are authorized to use Facebook on behalf of Senator Pileggi. As indicated in his letter, there is no charge to post information on a Facebook page. It can be made, posts can be made from any computer as long as you're logged in with the appropriate administrative role. When you post on Facebook, on a legislator's page, I wanted it to be clear what part of the letter was talking about. If you're using it as an administrator and I'm posting, for example, if I'm posting on Senator Pileggi's page, it shows up as Senator Pileggi with the post attached. So to a casual user, it would look like Senator Pileggi has posted this information. Now we make it clear, if you click on About the page, it's very clear that posts to Senator Pileggi's page are done by his staff. But I wanted the commission to understand that as well. Sponsoring a post, Facebook used to call it sponsoring, now they refer to it as boosting a post. It's basically paying for advertising. You can essentially set whatever amount of payment you'd like. It's paid by credit card, so the authorized user has to be connected to an authorized credit card for the payment to go through and for the transaction to happen. On this example, just to give you a sense of scale, this is one Senator Pileggi posted in relation to the storm that's going on now. 286 people saw it without payment, organically, as Facebook refers to it, and for $1.17, 403 additional people saw it as a result of the boost, just to provide a little bit of perspective. And when you boost a post on Facebook, when you advertise, you can choose the audience. This is very similar to targeting. For example, if a legislator wanted to send information about PACE and PACENet to constituents, you can target households with individuals over a certain age. In this case, on Facebook, you can choose geographical locations. You can choose people who have identified specific interests to Facebook, if you like, or you can simply choose people who like your page and their friends, their Facebook friends. That is the extent of my presentation. As I said, I'd be very happy to answer any questions.
Okay, thank you. Commissioners, now's our time to ask questions. Commissioner Nick?
Eric, bear with me if you will, because I do not use Facebook. But
Sure.
the question that I have, the request talked about putting legislative material on Facebook. And in that case, are you talking about actually putting the content, for example, of a bill, or legislative debate, or Senate calendars, or anything?
In some cases, members do that. One example that is one of the images in here, Senator Pileggi, we recently posted, youth suicide is a tragedy that occurs far too often. Today I was pleased to support House Bill 1559, which will, and it describes the bill a little bit. That's much more common. A bill passes, somebody posts information about why they supported it, why they opposed it. Anything that is in a member of the General Assembly's press releases certainly would be viable Facebook material. The winter storm notice, that was something that I saw many members doing. Here are the phone numbers for PECO, here is information on where to go to find a warming station, that sort of thing.
Okay. I don't have any problem with that. I guess where the question comes up for me is if the material is actually being posted on Facebook, the material presented for, say it's a bill, say it's a speech or legislative debate or a calendar, where the same site can be used to raise campaign money. I mean, I wouldn't think it would be problematic if the senator or anyone else would say Senate Bill 1559. If you want to see the full text, go to my official site, rather than actually putting the legislative material itself, which, I mean, it's kind of a gray area, I think, because it's public information, but yet the legislator has much more access, obviously, than anyone in the public would have. And anyone in the public can't get a bill drafted or can't do any of that. So I guess that's the only question that I raise is when you talk about posting legislative material on there, that material having been prepared at public expense, I think it's fine to reference it if it's, if the content or the actual document is on a public site.
I cannot recall an instance of seeing a member post the full text of a bill or the full, it's much more common for members to post links to those things. Facebook and most of what we're talking about here today would apply to Twitter and other social media as well. They're much more useful for short descriptions with a link to more information.
Okay, thank you.
I have a question. You indicated there are 5, what did you call them? And I also am not a big proponent or user of Facebook. You call them the administrators, is that correct?
Yes, I think for Senator Pileggi's page we have 4.
Okay. With that, are these people, are the administrators state employees? Are they staff members?
In Senator Pileggi's case, we have myself and 2 other members of his legislative staff. The 4th administrator is Christine Costello, who has no job with the state whatsoever. She is Senator Pileggi's, I'm not sure what her title is, she's involved with his campaign committee. At this point, she does not do anything on Facebook until we understand better what the rules of the road are, but she is currently set up as an administrator.
Now, in order to obtain a Facebook page, the Facebook, in this case, belongs to who?
A terrific question. I think technically in this case, the page under Facebook's terms of use belongs to me, because I'm the one who established it. Now, it is Senator Pileggi's page. I have no claim to it beyond that hyper-technical answer that I've just given you, but so I'm not sure if that's the answer, if I've answered the question or not. But.
Well, I'm trying to, I don't know the answer to the question. I'm trying to find out if it's your page, because the question is, we're looking at the request on behalf of the senator. So if it's the senator's page, and I'm really getting to this question, are you the one, if it belongs to you or has been issued to you, the login information, the access, and you're identified, can I use the term owner of the page? Would that be an accurate statement or not?
Facebook refers to me as the manager of the page.
You're the manager of the page. Well, what are the names that Facebook gives? I know there are administrators and there's a manager. The person who comes and says, I want a Facebook page, if that would be me, and probably not. But I want a Facebook page. What would I be called if I just came in and said, can I get one of these, especially since they're free?
Sure. If I may back up just one step. So the first thing is that you would sign up for a Facebook account. And a Facebook page is a separate thing. For example, I have set up a page for a blog I write about board games. So that's a separate page. I have Eric Arneson is just, I'm on Facebook as Eric Arneson, and that's not a page, that's just my account. And then Facebook allows you to set up what they call pages for organizations, individuals, that sort of thing. And so Senator Pileggi directed me to establish a Facebook page for Senator Pileggi. And so with that page, there are 5 types of administrators under the Facebook structure as it exists today. Managers, which is me, content creators, moderators, advertisers, and insight analysts. And what those titles mean, they basically just give you more or less access to the available information and the ability to post on behalf of Senator Pileggi. A manager having the most, and insight analyst just being able to review some statistics having the least.
So the person who signed up for the page would be given the login information and access?
That's right, and is a page manager, and then has the authority to appoint other Facebook members as different roles here.
So the person who is signed up for, let me back up. Senator Pileggi currently has a Facebook page, is that correct?
Yes,
Who signed up for the page?
I did.
You signed up. So you're the one who has the login information,
I do, yes.
and you can give that to other administrators or other people who have various roles and limit what the extent of their access may be?
That's correct. To be technically precise, I don't need to give them login information. As long as they have a Facebook account, I would go to this page where I set the administrative roles, and I can, if I may
Sure.
approach here, I would simply, in this box, type the name of somebody who is on Facebook, and Facebook would find them and come up, and then I would use this drop-down menu here to establish which level of access they have.
But when they post on the page, and that's called putting a message or some information on the page,
Right.
does it come out and appear to be attributable to Senator Pileggi? For example, if they put on there that we're gonna get 30 feet of snow tomorrow, would that come out under Senator Pileggi saying we're gonna get 30, posting that we're gonna get 30 feet of snow?
Yes, they have, you always have the option to determine, I can post on his page either as Dominic Pileggi or as Eric Arneson, but the short answer to your question is yes. That,
So that the senator may or may not know what information is being put out under his name from any of these people who have access to do so. Would that be a correct statement?
that is true, yes. It would be possible for someone to post information without the senator's knowledge or approval.
Okay, that's all my questions right
If I may expand on that briefly, I believe that each office has established rules and protocols to guide that process. There's not, to my knowledge, a single approach in that regard. For example, in Senator Pileggi's office, I have some flexibility with what I post. The other individuals who have access are not authorized. They could if they wanted to violate our protocol, but they're not authorized to post anything without my approval or Senator Pileggi's approval.
now. Is this protocol in writing?
It is not.
It is not.
It is not at this time, no.
So it's based on what they remember the protocol to be at any particular time?
It probably should be in writing.
I have a son, and I seem to remember this term, I forgot.
We've been using Facebook for several years now and have never had a problem, but it certainly could happen, and thank you.
Commissioner Carter?
Eric, Mr. Arneson, you preface each of your questions with assuming that absolutely no state resources would be used. Aren't the legislative documents themselves legislative resources or state resources?
I would say yes to a certain extent. As Your Honor indicated earlier, or maybe it was Roger, I think, actually, Mr. Nick indicated earlier, the state creates that information. However, it's then put into the public usage. So I don't think there's any question, for example, that if a candidate running for office wanted to say that they support Senate Bill 10 or oppose Senate Bill 10, that they could take the text of Senate Bill 10, and whether or not this individual is an incumbent, put the text of Senate Bill 10 on their website with notations and an analysis, what have you. So
Actually, instead of saying legislative material, which could possibly encompass anything that's over there, it could be confined to public legislative material, things that would be easily accessible under the right to know law, for example, or by the public.
that's fair. That's certainly what I envisioned when I was drafting these questions with Senator Pileggi. Our goal was not to talk about, you know, a draft of an amendment that never was offered, for example, but things that are commonly shared by legislators, for example, on their websites today, and now today on Facebook and Twitter as well. But we weren't intending to mean anything deeper than that.
Okay.
What about non-incumbents? Will they have the ability to access what you post on Facebook?
Yes, I can't think of anything that would fall, you know, behind some sort of a curtain that we've posted on Facebook. It's always trying to provide information about what is expected to happen, what did happen, you know, upcoming committee meetings, which are sunshined. You know, certainly a committee chairman could post on Facebook if they wanted to, that I'm going to have a committee meeting on Tuesday on such and such a topic before that meeting is sunshined. But today they could issue a press release with that same information, and I would suggest that there's no difference between those two approaches. So I don't think there's any you know, hidden treasure that non-incumbents don't have access to that that we're pondering in any way with these questions.
You, and following up on Commissioner Corrigan, there's 4 or 5 bullet points that says, assuming that no state resources. Aren't you a state resource? Isn't the computer a state resource?
Yes, without question, Mr. Chairman. And the intent of these questions, and we also included in the letter a segment of the Senate Ethical Rules of Conduct, were intended to get to the situation where either I, Eric Arneson, I'm at home on my desktop computer at 2 p.m. on a Saturday afternoon, as one example, or Christine Costello, who I mentioned earlier, who has no role with the state, is working on her smartphone or computer, that sort of situation. There's no question that if I am using a Senate computer or any state computer, but a Senate computer or Senate resources of any type, including electricity, that some state resources would be used. The questions are intended to get to the fact situations, as I described, where that would not be the case.
Christine is not a state employee.
She is not.
What have you heard or learned from what other states are doing in this whole social media thing, insofar as their government or the General Assembly is doing?
It's a terrific question. I can't say that I have any research beyond anecdotal evidence, looking at what other state legislators in other states have done on Facebook, and in my experience, it's been a mix, which is another reason we wanted to try and get some bright lines for Pennsylvania.
Chief Counsel Haley?
Eric, the General Assembly's website,
Yes.
are there links to these Facebook pages on that? Like, is it directing, or can people go from there to the Facebook page by clicking on something?
Yes, that's up to the individual member to request that link be added, but that's where I got the numbers that I listed earlier, at least 31 senators and at least 133 representatives. That's how many have links to their Facebook pages from the General Assembly website.
So do you see a difference between that situation where people actually are being guided to the Facebook page by a state website, and then they go to that Facebook page and there's campaign information, and maybe even, am I correct, maybe even the ability to donate, like a button you can click to donate money perhaps, or asking for money, versus the situation of something that's not linked up to the General Assembly's website? Is there a difference, do you think?
Seems like a question better suited for the commission to me, but I do see a distinction there. I think to answer one of your questions in there, I don't know. I've never explored. I don't have any role with Senator Pileggi's campaign, so I don't know if you can establish direct donation links from Facebook. I would be surprised if you cannot. I suspect that you probably can, and if you can't today, I would imagine that it would quite possibly become available in the future. And I think you raise a very important question, and one of the reasons for our submission to the commission is whether or not a Facebook page that mixes those things. You know, again, there's no question that if somebody was in our mind anyway, there's no question if somebody was doing this, you know, a non-state employee on their own time using no state resources could set up a Facebook page that linked to bills, linked to upcoming committee meetings, solicited donations, all those things combined. But you raise a very good question, which I don't propose to have an answer to today.
Can I ask another question?
Oh, you can ask all you want.
In terms of, and it's very interesting as this evolves, because we talk about state resources, and you acknowledge that during work hours, and especially using any state laptop, desktop, electricity, you are in fact, you become a state resource, a government resource, as well as the materials you're using. Is that correct?
Yes, ma'am.
Now, in these administrative roles, we have people who would not fall into that category. If we have someone who's not a state employee, using their laptop, desktop, wherever they choose to use it, but we're all feeding into this same page. Is that correct?
That is correct.
There are certain things that public officials cannot do. We acknowledge that, that's why you're here, correct?
Yes.
But these other people could do anything that they may choose to within the confines of the law, and it's all feeding into the same page.
That's correct. It is a unique situation that Facebook presents here, and other social media. But your description is absolutely accurate.
I want to understand your understanding of the request. Are you asking us to pass upon the activities of people not subject to commission ethics laws?
In part, I think we are, because their action, somebody authorized them to access the page in that way, to have the ability to post to the page. Presumably, we're not talking about a situation where, I think it would just confuse matters if we tried to talk about situations where a rogue somebody out there set up a fake Dominic Pileggi page. So confining ourselves to legitimate pages like this, our question is in part to make it clear and perhaps using specifics makes things more understandable. Can a campaign employee who works for I think it's Friends of Senator Pileggi, can that person post through a page that either Senator Pileggi, in this case I created it, but that's exactly right. We're wondering if the commission can illuminate that question, what the answer to that question. What problems, if any, with relation to the Ethics Act could Senator Pileggi get into if one of his campaign staff, who is not subject to the Ethics Commission, does that activity?
And just following that along just a bit, because what I'm trying to get to the nub of, who's with the responsibility and the authority to have the page and to give access to others, who's ultimately responsible for what's on that page?
Senator Dominic Pileggi.
So if someone who is an administrator, I'm not talking about, as I understand it, people come in and post all kinds of stuff on your page, but I'm talking about the administrator or someone with the authority to post under the name of Dominic Pileggi.
Right.
Dominic Pileggi here is representing to this commission. He stands behind and should be held accountable for any violations or non-violations under the Ethics Act by those people, including yourself. Start with someone you know first. Before you go to those other people.
In the same way that Senator Pileggi is responsible for what is posted to his more traditional website, I would suggest that the answer is yes. He is ultimately responsible. Now, if I walk over to the Senate today and decide that I'm going to post links to some sort of political fundraising apparatus on his Facebook page using a Senate computer in flagrant violation of what we all know to be the law, I'm not in a position to judge whether he would be legally responsible in some way, but certainly it would come to him to, in the public's eye, explain that Eric Arneson, now my former employee, did these actions without my authority, without my approval. I apologize for them, and we've taken steps such as a written policy to ensure that it does not happen again in the future. Does that answer your question?
Yes, and to some extent, privacy settings. Because
Yes.
while I alluded to the fact of any and everybody posting on your page, and this is something I've heard about,
Yes.
privacy settings. Are there any privacy settings? Can people come and post any and all manner of, they call it communications information, but I'm gonna call it stuff for the time being, on this page?
There are a number of settings. On Senator Pileggi's page, we have it set up so that people can respond to posts made on behalf of Senator Pileggi, and they can post whatever they like in response to that, and often do. The other options include having a page that is not interactive in any way, so people can only read what has been posted on behalf of a legislator, or on the other end, allowing people to even start new discussions. So we've chosen the middle ground for Senator Pileggi. There are members of the General Assembly who are in all three camps. It's been an individual choice to date. We have established one written policy we do have on Senator Pileggi's page. I mentioned that if you click on the about, the word about on Senator Pileggi's page, you will see that updates are made by staff. You will also see terms of use that include, no defamatory postings will be deleted, threatening postings will be deleted, off-topic postings may be deleted, a number of rules and regulations along those lines.
Who monitors that and how frequently?
I do every day. The other administrators, the two other legislative administrators, do less frequently, but I do that on a daily basis during the work week. Typically, I go in a couple times on the weekend as well.
A final question about the blending of people posting who are not state employees. And on this webpage where you may have people who, one, may be more cognizant of the rules and restrictions and prohibitions as to information can be posted, and other people who are posting what they want if we've got a campaign-related website or anything else. Is there a reason why you wouldn't have two websites with a link for those who are governed by and subject to state requirements, with a link to another webpage where people who are not so restricted and presumably would not perhaps have access to information that other state employees would have, to post whatever they want, and also are not subject to this commission's jurisdiction?
There is no technological reason not to do that. The only practical reasons not to do that would include the necessity of maintaining 2 pages rather than 1, the question of how do people find both pages. Do you post, for example, the information about bills that have been passed? How many people have liked both pages, so am I duplicating information to those people? Those kinds of questions. There's no technological reason that couldn't be done. It would just be a series of practical questions along the lines that I've just laid out.
Yeah, as I've listened to your presentation, a couple of legal issues have come up that I didn't really see coming. And so I have to raise this now for you and for you to consider. The senators letter requesting the advisory, the questions are posed as to legislators. Now, of course, the commission has standing requirements, and that one I saw coming. That, you know, the senator has not indicated that he has the permission of any other legislators, and they're elected officials, you know, to ask on their behalf. It's really got to be directed to his own prospective conduct at this point. And that's doable unless we have a past conduct problem, and this is the part I didn't see coming. From the face of the advisory request letter, there was no indication that the Facebook page was already up and running. And I mean, you've indicated that, you know, you're the manager and you created this thing, and I don't think you said yet whether you did that on a state computer on state time. So that's maybe one question of whether it is already a government resource, this particular Facebook page. I guess he might be able to have multiple ones, so maybe that's surmountable. But then you have the other question of, has any of this already occurred? Has there already been a commingling of campaign information and legislative material, which, without even getting to the question of the merits, if it's already happened, they can't answer this advisory request. Maybe you could come back with another one for someone else who hasn't done any of this yet. But there are those problems which I'm seeing now.
If I may, please.
If there's 33 senators already doing this and 131 House members, you're already doing it, and then you're coming to us to say, tell us it's okay that we're doing it. That's what I'm getting at.
Oh, I apologize if I've left that impression. There has been no commingling on Senator Pileggi's Facebook page. I created the page. I could not honestly tell you today if I did that at home or I did that in my Senate office. It takes about 10 minutes to do. I could very easily have done it in either location. I honestly have no recollection whatsoever.
Is it possible for him to have 2 Facebook pages?
It is, and in fact, at this point, he does, out of an abundance of caution until we understood the rules of the road. There is, I don't know the address to it offhand, but there is a Dominic Pileggi for Senate or Friends of Senator Pileggi, whatever they've called it, campaign Facebook page that exists.
So given your representation today that there has not yet been any commingling of legislative information and campaign information, is your question then directed, since you don't know if the current Facebook page was created on state time, is your question posed in the context of perhaps creating yet another new Facebook page where that commingling would occur? In other words, I'm trying to help you see a way around maybe a past conduct problem.
Yes.
I thought so. And alternatively, you could submit a different request in the name of someone who hasn't even got a Facebook page yet.
I would proceed in whatever way the commission thought most useful. The numbers of 30-plus senators and 133-plus representatives are the at least number. The number of members without Facebook today is small and rapidly dwindling. That would certainly, as we sit here today, be a possibility that I could do that, and I'd be very happy to if the commission thinks it's most useful.
So ultimately, Eric, if we said everything was okay in your request, you could take the 2 pages that Senator Pileggi now has and make 1 page out of them, and everything would be combined on the same page.
I think so, yes. I'm not certain that we would do that, but I think that would be one potential outcome.
Commissioner Bergen, Commissioner Caulfield, any questions?
No, I don't have any questions.
No, not on my end. It's been fascinating discussion.
Yeah, you've taken us to new heights or new horizon.
Mr. Chair, this is unusual, I know, but sometimes the chair will ask if there's any other input from the audience, and I noticed that there are representatives of different caucuses here. I don't know whether they would want to speak. I'm just wondering if that's appropriate to extend the invitation, if they have anything they want to say.
Yeah, well, we certainly wouldn't object if any of the other members of the other caucuses want to comment, you used the word illuminate. You said you haven't been illuminated and you want us to help illuminate you.
Yes, sir.
Okay.
Mr. Chair, I do see a hand.
Oh, I'm sorry.
Eric Philman.
Yep, please come forward.
Good, how are you?
Please, for the not name.
Thank you. It's Eric Philman, F-I-L-L-M-A-N, Deputy Chief Counsel of the House Democratic Caucus. Thank you for the opportunity. I did not anticipate this, and I'm grateful for it because I give Mr. Arneson a lot of credit for coming forward. There are so many questions with all of the new social media technology. We face them regularly too. One of the key issues for us in a caucus is wrestling with, I think Council Hiddy touched upon this, the creation of the page. If a page was initially created, we'll say in-house or outside, has become a little bit of an issue for us because we face similar questions. And my way of thinking is that is de facto already state resources having gone to produce something that may evolve into something that is no longer a state resource. If the commission would, as they pass upon this question, consider that issue, we would appreciate such guidance. I make no representation one way or the other as to how I think that should come out. I know we face the question. Again, I give Mr. Arneson all the credit in the world for coming forward on this because we have just as many questions in our caucus, and we would appreciate any elucidation that the commission would offer.
So, Eric, what you're saying is that the mere creation of that Facebook page makes it a state resource in and of itself.
I'm asking the commission to consider whether that is the case. Part of the problem in this whole era is this stuff exists elsewhere. It exists on Facebook's server somewhere out there. I appreciate the judge's questions about who owns it, where did it come from. We wrestle with the same thing. Sometimes members direct their subordinates to do such things as create social media. In part, in our caucus, we have created state resources dedicated to creating and maintaining those. But Mr. Arneson is speaking of something that is, at a minimum, a hybrid and perhaps ultimately completely independent. All I'm requesting is, when the commission considers this, we would appreciate guidance on whether or not, for example, something that may have been created in-house but is essentially used and no longer supported by state resources, whether there could be clarification on that. I did not intend to make a further request on this. I simply am grateful for the opportunity to ask the commission to consider whether the creation using state resources is enough to trip this, or whether something evolves into an independent light, whether that's determined. I leave it to the commission to figure that out. I think it's a significant question.
Commissioner Nick?
Eric, just to follow up on that, and representatives from the other caucuses as well, there are no policies by the caucus for staff when they develop it for a member, or any written policies per se indicating how it can be used. I don't know, you can actually control what a legislator does with a Facebook page that is not owned by the state, but since it was created with public resources, are there any guidelines created internally that address that?
I imagine each caucus has some measure of direction on this. Whether they're reduced to writing, I would not say. My experience with legislators has been that they're exceedingly careful about what and how, what they post and how they use these pages. Understanding that, the political world is a volatile world. And we all understand that the inappropriate use of state resources is illegal under the Ethics Act. So I think we have walked a very careful line. And I think all four caucuses are attempting to continue to walk a careful line, and which is precisely why Mr. Arneson's here today.
Mr. Nick, in the Senate, the Senate Ethical Rules of Conduct, which are one of the first resolutions that are adopted each session now, do have some guidance in terms of using social media. A portion of those are included in Senator Pileggi's letter to the Commission, of course. As I recall, there is a little bit more both before and after the section that was quoted in the letter.
Does that other information govern what people can post or who can post?
It does to a certain extent. Obviously, if there is a conflict between the Senate rules and the Ethics Act would rule. It does. The Senate Rules of Ethical Conduct indicate in a nutshell, and I'm not suggesting that I'm remembering them in their entirety off the top of my head right now, but that a Senate employee who is on Senate time and/or using Senate resources cannot do anything campaign related, including posting to social media. However, if they are off time, off resources, for example, me at my house Saturday at 2 p.m., on his or own time using personal resources, may post material involving or referring to campaign activity on a social media website. Now that was intended to encompass both the kind of thing we're talking about here today and, you know, if I was working as a campaign volunteer for a county commissioner in my home county or something like that. So it was written more generally than what we're talking about here today, but it was intended to cover both of those kinds of situations.
Mr. Hatcher?
Thank you, Mr. Chairman. Can I address from back here? For the record, my name is C.J. Hafner. I am Chief Counsel to the Democratic leader, Senator Jay Costa. Not on behalf of Mr. Arneson, because this is a bit of an awkward situation, the cross-party as it is. But perhaps I could suggest to Mr. Arneson and the Commission that he would submit a copy of the Senate Ethical Conduct Rule in question. That might be helpful for the Commission's guidance and input on the matter that Judge Lewis is asking about.
Thank you.
Yes, I will certainly do that, and Mr. Hafner and I agree on about 99.5% of things, I think. I will certainly do that.
That's in the record.
I wonder
Thank
if
you,
we
CJ.
all agree on 99.5%. Any more questions for Mr. Arneson? Judge Lewis?
Mr. Chair, I would suggest at this time that we take a brief recess from the public meeting to engage in quasi-judicial deliberations in executive session before we decide this matter.
Okay, I'm sorry that we have to do this, but you can tell from all these questions and everyone, this is a new territory for us and we need to discuss it. Okay, thank you. As you can imagine, like we had an interesting discussion while you were here, we had an interesting one while you were gone. This time I'd like to call on our Chief Counsel, Robin Hitty, to tell you where this commission has what we unanimously decided.
Okay, at this point, the commission will not be able to rule for various reasons, one of which is Eric Arneson, you said you're going to submit more information, so obviously, they can't rule today no matter what. However, the commissioners feel that you might want to, during the time to come before they would rule, consider whether the questions you have posed are the questions you're really looking for answers to. Because as posed, the questions basically say the commission is to assume absolutely no state resources would be used. if they answer the questions as you have posed them, I don't think you're really getting the information you're looking for, because you've, through your presentation, indicated that there may be some state resources being used in what you're contemplating. So you might want to think about that. Your options would be, I guess, if you decide this really isn't the advisory request you want them to rule on, you could always withdraw it and resubmit a new one. As the requester, it is entirely up to you whether you seek any kind of additional input from other caucuses. If that would come, it would come through you, because you are the requester. So those are things you might want to think about. And that's basically the procedural aspect. At this point, they can't rule. At the earliest, it would be their next public meeting. In the meantime, you'll be submitting information, giving some thought to whether this is the advisory request you really want them to address. And Judge Lewis, do you have other?
I think you've accurately captured the sentiments, and thank you very much, because some of the information, as you know, the whole area of Facebook and social media really poses some unique questions, and as you pointed out, we can't see what the next step or the next frontier may be, but consistent with the Ethics Act and trying to look at that, we do invite you, one, we look forward to the additional information, and invite you to, in light of the discussion, to formulate what is the actual question you want us to respond to based on information that has been shared and consistent with what your real desire is and what you're really looking to do prospectively. Because I think that's something that will help us in understanding and being able to appropriately respond under the Ethics Act.
And I would be interested, as I mentioned earlier, if there's any other states that have addressed this.
Thank you. If I may, I appreciate that, and we'll certainly proceed in that direction. Is there any particular date by which additional information or perhaps a withdrawal and resubmission would be most helpful to the commission?
Well, typically, the commission, they haven't set their next public meeting date, right, Rob?
It hasn't been set.
Yeah, I mean, typically, what, April or May or something? would be-
April will be sometime.
Probably April,
Okay.
So you need to have it
but we need
in
it prior
advance
to
of
that.
that.
So if, by way of example, we were to have something in your hands by the end of February, that would be, thank you.
Thank you.
Anyone else have any comments? Okay, thank you very much. It's been an interesting discussion.
Thank you.
Thank you.
Thank you.
Okay, thank you all for your participation. Next item on the agenda, Corey Mann, and I believe Commissioner Caldwell, you have that case.
Thank you, Mr. Chairman, and I hope you guys can hear me well.
Yes,
Yeah, we can.
yes.
In this case, the requesters are Rodney Corey, Esquire, Chief Counsel for the Republican Caucus of the Pennsylvania House of Representatives, and James Mann, Esquire, Chief Counsel to the House Republican Leader. This request is substantively the same as the request we recently addressed in Corey Mann Opinion 13-006, Opinion 13-006 regarding legislative mailings to new legislative districts following redistricting, which was also the subject of Longietti Opinion 13-002 of this commission, and the use of public funds to pay expenses for the transmission of electronic mail or robotic telephone calls for mass communication to residents of new legislative districts, or the conduct of town halls, fairs, other types of events in new legislative districts. This request has been submitted on behalf of 22 state representatives whom I shall refer to as the state representatives. The state representatives seek to be able to rely upon Opinion 13-006 with the same status and protections afforded by law to the individuals who are the subjects of Opinion 13-006. The state representatives have not submitted any additional facts or questions beyond those stated in Opinion 13-006. Therefore, Mr. Speaker, I move that the holding of this commission in this matter be as follows.
Excuse me, Mr. Colafella?
Mr. Caulfield,
Yes,
there are guests here that may want to comment, speak to this matter.
oh, I'm sorry, I'm sorry,
And plus, you promoted me to speaker.
Old habits.
Mr. Speaker?
Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on this behalf, on this matter. Mr. Chairman, given that this advisory request,
Excuse me, Mr. Colafella?
They're here to
They're
speak.
here to speak.
I'm sorry,
And also, Mr. Chair, while they make their way to the podium, I'd just like to note something for the record. I had discussed this with you, that one of the representatives on the list is someone I'm personally acquainted with, Representative Steve Bloom. Had a former business relationship with him. It is not ongoing. Not close personal friends, but have known him for many years. I have not formally recused myself from my role as chief counsel in this matter because he's just one of 22. Have no intention of having further business relationships simply because he is a state official. I choose not to do that. But I want to note that for the record. If it became significant to have me participate, I probably would recuse myself.
Okay. The record will note comments of Chief Counsel Hitting, and there's absolutely no problem. Mr. Cord, please proceed.
Sure, just to state for the record, my name is Rod Corey. I'm counsel for the House Chief Counsel for the House Republican Caucus, and with me is Jim Mann, who's Chief Counsel for the House Republican Leader. To the extent we could offer our endorsement, we see no need for Chief Counsel Hitting to recuse herself. We're fine with her participation. Just very briefly, and I think Commissioner Colafella summarized everything, and we appreciate the Commission's patience in a fairly unique situation, and to the extent he was ready to make the motion, we're willing to sit down and let that proceed.
Please proceed, Mr.
I've got my sheets all messed up here. That's the problem when you stay at home. Anyway, I move that the holding of this commission in this matter be as follows. The state representatives are public officials subject to the provisions of the Ethics Act. The Ethics Act would not prohibit the state representatives from using public funds to pay otherwise allowable expenses for postage and printing services for otherwise permissible mailings of items constituting official business to residents of their new legislative districts as determined by the final reapportionment plan of the Legislative Reapportionment Commission affirmed by the Pennsylvania Supreme Court. Such items constituting official business would include non-political newsletters, birthday and congratulatory greetings, and notices of upcoming legislative meetings and forums as delineated in Longetti Opinion 13-002 of this Commission. Under the submitted facts of Opinion 13-006 of this Commission, Section 1103A of the Ethics Act would not prohibit the state representatives from using public funds to pay expenses for the transmission of electronic mail or robotic telephone calls for mass communication to residents of their new legislative districts, or the conduct of town halls, fairs, and other types of events in their new legislative districts, subject to the condition that such expenditures, one, would be for official business in compliance with the general operating rules of the House, or two, would fall within the de minimis exclusion to the Ethics Act's definition of the term conflict or conflict of interest. Therefore, Mr. Speaker, I move that the holding of this commission in this matter be as follows. Let's see if I can find it.
That's it.
You
That was it.
finished it.
You just did.
That's it. I need a motion, I guess.
You moved it. Second.
Okay, it's been, motion made by Commissioner Colville.
Yes.
Do I have a second?
Second.
Second by Judge Lewis. Any questions or comments? If not, all those in favor say aye.
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 Any opposed? Motion adopted. Thank you, Commissioner Colville.
Thank you. I'm sorry about
No problem, no problem.
all these papers that have been sent to us. It's pretty difficult sometimes to put it all together, but I finally did.
Okay. Thank you.
You're welcome.
Thank you, Mr. Mann, Mr. Corey.
Thank you, Commissioner.
Thank you.
You can tell Sam that I'm the new speaker. Okay, thank you very much. Moving on, item number 4 on our agenda, Claycomb, appeal of advice on council. Commissioner Nick, please proceed. For Commissioners Colifell and Bergen, we have 3 additional guests that are here in conjunction with this case. Mr. Nick will proceed.
The facts pertaining to this appeal of advice are as follows. The appellant is Carrie B. Claycomb. Mr. Claycomb has appealed advice of counsel 13-581, which was issued to him on November 20th, 2013. Mr. Claycomb currently serves as the appointed secretary for the Borough of Berlin, which I shall refer to as the borough. Mr. Claycomb also currently serves as the appointed corresponding secretary for the municipal authority of the Borough of Berlin, which I shall refer to as the authority. Mr. Claycomb is contemplating retiring from his positions as the borough secretary and the corresponding secretary for the authority. The president of Borough Council has asked Mr. Claycomb to consider acting as a consultant, probably contracted by the hour, to Borough Council after his retirement. The Authority Board has similarly asked if Mr. Claycomb would act as a contracted consultant to the Authority Board upon his retirement. Mr. Claycomb requested guidance as to whether the Ethics Act would permit him to act as a consultant to Borough Council or the Authority Board after his retirement. Advice of Counsel 13-581 determined that in each of his positions as the Borough Secretary and corresponding secretary for the authority, Mr. Claycomb would be considered a public official subject to the Ethics Act and the regulations of this commission. The advice further determined that as to each of his aforesaid positions, upon termination of service in such position, he would become a former public official subject to Section 1103G of the Ethics Act. The advice determined that the governmental body with which Mr. Claycomb would be deemed to have been associated upon termination of his service as the Borough Secretary would be the Borough Council. The advice further determined that the governmental body with which Mr. Claycomb would be deemed to have been associated upon termination of his service as the corresponding secretary for the authority would be the authority in its entirety. The advice set forth the restrictions of Section 1103G of the Ethics Act as applicable to Mr. Claycomb. The advice concluded that during the first year following termination of his service as the Borough Secretary, Section 1103G of the Ethics Act would prohibit Mr. Claycomb from entering into a consulting contract with Borough Council and/or providing consultant services to Borough Council with promised or actual compensation, as such activities would constitute prohibited representation of a person, himself, before Borough Council. The advice further concluded that during the first year following termination of his service as the corresponding secretary for the authority, Section 1103G of the Ethics Act would prohibit Mr. Claycomb from entering into a consulting contract with the Authority Board and/or providing consultant services to the Authority Board with promised or actual compensation, as such activities would constitute prohibited representation of a person, himself, before the authority. By letter dated December 19, 2013, Mr. Claycomb appealed Advice of Counsel 13-581. Mr. Claycomb's appeal letter did not state any particular basis for this appeal. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
Gentlemen, are you here to represent Mr. Claypool?
Thank you, Mr. Chairman. I'm Mr. D. Phillips, Terry D. Phillips.
Pardon me?
Mr. D. Phillips, Terry D. Phillips. I'm president of the Borough Council of Berlin.
Okay, did you get that, huh?
Yes, I did.
And I just want to give a little background, you know, if Mr. Claycomb has been our executive secretary for a little over 39 years. At the little town of Berlin, we only have 2,100 people, and it's awful difficult to get anybody even to be on the council, let alone stick around and put up with all that. In our office there, we only have 2 full-time people, and Mr. Claycomb and our treasurer, and we have a part-time clerk that handles the billing. And then we have several other full-time, but they're the garbage, pick up the trash and so forth. This past election, just as a background why we would like to be able to have Mr. Claycomb as a consultant. I was elected in November. Of course, last month in a reorganization of the council, my fellow council members elected me president. We have 3 other new council members. We have a new mayor, a new solicitor, and Mr. Claycomb is planning on retiring around 31 March. And when we look at what he's done over the years, his institutional knowledge and all the new people on board, we said, gee, it sure would be nice if we, even when he's retired, sitting here at his home in Berlin, when it comes time, but he's been the only one that has done any work on grants, preparing grants. And over the years, I think he has gotten for Berlin something a little over $4 million in grants because of his ability to write those things and get them approved. And it's been on his own. So we'd like to have him there whenever something comes up, whether it's a grant or his institutional knowledge, that say we could contact him and have him come in and help us out. It's not that we're going out and going to a consulting company or firm and asking to bring him in. If he's just strictly from the borough going council, going to get his knowledge, all his years of service. And that's why we want to appeal the decision. So that we wouldn't be waiting a year to get everybody up to speed when something comes up. Now, if you want to answer any questions, if anybody has any questions.
Any commissioners have any questions? Thank you very much. Any others want to comment?
I'm Scott Miller. I'm the chairman of the Municipal Authority for Berlin. We basically have the same problems that Mr. DePhillips has. You know, we're just a 5-member board, and we just wanted him to consult with from time to time for the same reasons that Mr. DePhillips stated. That's pretty much it.
Mr. Chair, I have a quick question. Under your retirement plan, oh, okay, you wouldn't know the answer, I'll wait then for it.
Hi, I'm Kerry Claycomb, I'm the Borough Secretary, corresponding secretary for the Borough of Berlin. I've been such for 39 years, and retirement's knocking on my door. And it wasn't that I was, just to put it in perspective, I wasn't approaching these people, and they were approaching me, and that's why they came here. The Pennsylvania Municipal Retirement System, when I talked with them, and we participate in that, the municipality does, and that's where I would draw a pension. And they have policy, they tell me, and they even sent some, and I don't have it with me, but that I can't continue as an employee and draw a pension. So there's a possibility maybe of some temporary, but I don't know if that gets into the same issue. If it's more than a year, you know, they view temporary as less than a year, period. And if you're an employee, even temporary, when you leave, is another year fall into place under the Ethics Commission's regulations. So it's like there's no end to it. And I don't think the PMRS would allow more than a year to look at temporary employment to assist. Like our council president said, we're a small community. We own an electric distribution system. We're like 34 other municipalities. It has its own issues. And if you lived in Berlin and your power went out tonight, you call me. You know, and I get the electrician to come in and take care of things for you. We have a refuse collection system. Our municipal authority operates the water system. They operate the sanitary sewer system. And it isn't that I don't know where you live, but our sewer rates for, just as an example, for a month are $18 flat fee. If you use 4,000 gallons of water in a month, it's about $13 for a water bill. Our electric is less than the investor-owned utilities. We're probably about 10 to 11 cents a kilowatt hour. And our refuse for at least 6 bags of garbage a week is by the month, it's $12.35. So our millage is only 1.5 mils of property tax for the municipality. We can go to 30. It's been managed well over the years by dedicated elected officials. I'm an appointed official. As I've told these people, under Borough Code, you serve at pleasure of council, and I've been on probation for 39 years. So, you know, I could be, you know, they could say goodbye anytime, as with a solicitor or treasurer. So the effort here wasn't to, the request was because Shelley Houck, God bless her, I love Shelley Houck with the Pennsylvania State Association of Boroughs, very knowledgeable individual. I talked with Shelley and I said, this is my plan. I can't draw pension and continue as an employee because of the pension regulations, and I'm thinking they're asking me to consult. Do you see any issues? She said, you better write to, she suggested, she doesn't direct, she said, you may want to consider writing to the Ethics Commission to get an opinion. And so I did, and I got an opinion, and I shared it with these people and their respective Borough Council and the Authority Board. And they said, and I debated and debated whether to even appeal. Just wanted to explain the circumstance. I don't know. I didn't bring an attorney with me. I'm not an attorney, neither of these gentlemen. I didn't prepare a brief. I didn't send any of it. We're just asking if there's any possibility of permission to assist, for me to assist them for their request. I don't know how else to otherwise to do it. I don't know. We're open to suggestions, by the way.
Council Ed?
Yeah, if I can just give a little bit of background and explanation, and then I do have a question for you that I don't know if will help you or not.
Okay.
But legally, which is my role, you know, give legal advice, the revolving door provision is something that the commission hasn't been given leeway to craft exceptions, to give waivers. The General Assembly, when they passed the law, they didn't give this commission the power to accept people out from under this restriction. To add to that, you've got decades of precedent on this that say that, you know, a person can't leave the governmental position and then come back as a consultant during that first year. There's also precedent that talks about annuitants in the state system, and I didn't know, you're kind of getting into, that's what I was going to ask about your retirement pension, you're kind of getting into talking with them. I don't know whether that system allows it or not, but at the state, when someone retires, there is an ability to come back under a 95-day emergency return to work provision, where the person can come back and work up to 95 days during that year, helping out their old agency. They are considered employees again. They do withholding. I mean, they're treated as employees, and in fact, that's the only way they can do it under this revolving door provision, is actually to become employees again for those 95 days. When they leave that annuitant position, and I'm assuming they're doing basically what they did before, they're covered under the Ethics Act, it's that kind of role. When they leave the annuitant position, they do, once again, start the one-year clock. But there's no limit on how many times, under the Ethics Act, there's no limit how many times they can come back. They have to meet the state criteria, of course, under this provision to participate. I don't know whether your retirement system has that kind of provision or not, but if it did, and you would once again be, in our eyes, the Commission's eyes, subject to the Ethics Act, the revolving door provision would cease to apply for that time, and then would start again once you left. Just wanted to add that clarification.
And I'm not sure about the annuitant. I know the pension plan we have was started in 1987 for employees such as myself. I've worked there since 1975, so it's a defined benefit, not contribution plan. And so it's 1.5% a year for every year of service. That's how they calculate the pension. So for whatever, from 87 until now, that's 1 times 1.5, that of your, I think, 3 high years average. You know. That's how it's calculated. I don't know if that would be considered that type of a situation or not.
You have to ask them. But the commission has many times over the years not only addressed this question, but other compelling situations. I mean, we're not made out of stone. We get it. We feel bad for you. I feel bad for you. But we get this question often from PennDOT. You know, it comes up all the time. And you've said so many times that you can't make an exception. You don't have that statutory authority. And your own precedent says, and has said for decades, that it applies to this type of situation, which is why the advice said what it said.
So, if I may, if the pension plan would agree in some fashion with this annuity situation or as annuitant, and you can serve as you can continue to serve as an employee, but not a consultant. Is that the?
Right. You can't, and that's kind of going to be governed by their plan, whether
Right.
they can do that without harming your pension. As long as you fall within the protections of and requirements of the Ethics Act as a public employee, in whatever form that takes, that revolving door provision stops at that point. When you leave, it'll start again.
The revolving door is the 1 year.
Yes.
The 1 year.
1 year, right. No, that was clear in the opinion. She wrote a detailed advice of counsel or whatever it was called. So it was, I understood that. I didn't know if there was any leeway, you know, it was worth a shot, you know, to check with you. Okay, thank you.
Thank you, Mr. Claycomb. Mr. Nick?
I'd just like to emphasize and back up what Robin said. I think there are times we wish we had more leeway in our ability to define or interpret the Ethics Act, but unfortunately we don't. And we do appreciate you taking the time to come here. It's not an easy trip, and I'm from a rural area, small town myself, and they own their own electric company.
Oh, really?
I know. Smethport up in McKean County.
Which one is it?
Smethport up in McKean.
Oh, Smethport,
Yeah.
absolutely.
Okay. Well, unfortunately, I'll have to proceed with our statement.
Do you want to speak anymore?
I just wanted,
Oh, sure.
just wanted to thank you for, hearing our case, and we just, as I tried to point out to you, and I understand you're in a block, you can't do it, but we just said, hey, we got so many new people coming on, and it'd be great to be able, whenever we need them, to pick the phone up and just call and say, hey, we need your help on this, or we need to tell us where the bodies are buried, or whatever they're.
One last point, of course, I'm not directing this at you, but there is an ability, this revolving door provision is geared toward people who are being paid. So obviously, in an emergency situation, if you called, Mr. Claycomb and he was willing to do this for free or something like that, that's not prohibited. I'm just mentioning it.
Okay.
Well,
But you can't really, what I understood from you can't have a promise of compensation later.
no, it's promise
But
correction.
did I get that right?
You're correct.
Okay.
It has to be a legitimate, free service that you're doing.
Exactly.
Yeah, we didn't write the law, we have to enforce it.
I understand. Thank you for your time.
Thank you.
But we're not quite finished.
Oh, go ahead.
We have to dispose of these. Mr. Chairman, I have reviewed the facts and relevant statutory provisions. It is my view that in each of his positions as the Borough Secretary and the corresponding Secretary for the Authority, Mr. Claycomb would be considered a public official subject to the Ethics Act and the regulations of this commission, and that upon retiring from each of these positions, Section 1103G of the Ethics Act would apply to Mr. Claycomb. Based upon the Ethics Act, commission regulations, and commission precedent, it is my view that the advice of counsel was correct, and that during the first year following termination of his service in either position, Section 1103G of the Ethics Act would prohibit Mr. Claycomb from entering into a consulting contract with his respective former governmental body, specifically Borough Council or the Authority. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. In each of his positions as the Borough Secretary and the corresponding secretary for the authority, Mr. Claycomb would be considered a public official subject to the Ethics Act and the regulations of this commission. As to each of his positions, that is Borough Secretary and corresponding secretary for the authority, upon termination of service in such position, Mr. Claycomb would become a former public official subject to Section 1103G of the Ethics Act. The governmental body with which Mr. Claycomb would be deemed to have been associated upon termination of his service as the Borough Secretary would be Borough Council. Under the submitted facts, during the first year following termination of his service as the Borough Secretary, Section 1103G of the Ethics Act would prohibit Mr. Claycomb from entering into a consulting contract with Borough Council and/or providing consultant services to Borough Council with promised or actual compensation, as such activity would constitute prohibited representation of a person himself before Borough Council. The governmental body with which Mr. Claycomb would be deemed to have been associated upon termination of his service as the corresponding secretary for the authority would be the authority in its entirety. Under the submitted facts, during the first year following termination of his service as the corresponding secretary for the authority, Section 1103G of the Ethics Act would prohibit Mr. Claycomb from entering into a consulting contract with the authority board and/or providing consultant services to the authority board with promised or actual compensation, as such activities would constitute prohibited representation of a person himself before the authority. The appeal is denied. Advice of counsel 13-581 is affirmed.
Thank you, Mr. Nick. Is there a second to Mr. Nick's motion?
Second.
Okay, any questions, comments? Okay, all those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Probably not what you wanted to hear, and it's tough for us too, but we understand your position, but the law is the law.
My sense of humor, the compensation include, if he's willing to work for food, is that covered?
Send in another advice.
Don't ask us.
Sorry.
We don't go with it.
Thank you. Thank you for your time.
Thank you very much.
Thank you.
Okay, thank you, Mr. Nick. Almost finished. Item number 5, civil penalties, orders default, Commissioner Bergen. I think you have been signed up.
I have. Thank you, Mr. Chairman. There's 2 civil penalty default cases that are now before this commission for decision. These cases involve respondent Aaron Kalla and Paul F. Amon. Respondent Kalla failed to file a statement of financial interest for calendar year 2012, and respondent Amon failed to file a statement of financial interest for calendar year 2011. These respondents did not file timely answers or respond to the civil penalty proceedings. Following review, it is my opinion that of each of these respondents, the Commission should levy a maximum civil penalty of $250 for the delinquent statement of financial interest. It is my opinion that the Commission should also order these respondents to file their delinquent statement of financial interest. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based upon my analysis and comments, I would like to make the following motion. I move that this commission levy a maximum civil penalty in the total amount of $250 against each of the following respondents for failing to file a statement of financial interest for the respective calendar year. Aaron Kalla, calendar year 2012, and Paul F. Amon, calendar year 2011. Further, these respondents shall be ordered to file their statement of financial interest for the year stated within 30 days of the issuance of the commission's order. So moved.
Thank you. Is there a second to?
Second.
Second by Commissioner Corrigan. Any questions, comments? All those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Thank you, Commissioner Bergen. Okay, next item on the agenda, item number 6, Alfano Dion. Commissioner Corrigan has been assigned that case.
This
Please
is-
proceed.
Thank you, Mr. Chairman. This is a gaming determination. The requester is Attorney Gaetan J. Alfano. Mr. Alfano has requested a determination from the commission on behalf of his client, Pasquale T. Dion Sr. Mr. Dion currently serves as a Turnpike Commissioner. He also serves as a board member of SEPTA and the Bucks County Industrial Development Authority, which those two I shall refer to collectively as the authorities. In a private capacity, Mr. Dion holds preferred stock in Sands, Pennsylvania Incorporated, and he's required to hold a principal license with the Pennsylvania Gaming Control Board. Mr. Dion's first principal license was approved by the Gaming Control Board in 2008. His license was approved for renewal in 2010 and 2012. His most recent renewal application is currently being processed. To assist the Bureau of Investigation and Enforcement in reviewing Mr. Dion's renewal application, Mr. Dion has been asked to obtain a determination from this commission pursuant to Section 1512A.51 of the Gaming Act as to whether his service as a Pennsylvania Turnpike Commissioner, a board member of the authorities would bring him within the definition of the term public official as set forth in the Gaming Act at 4 Pennsylvania Consolidated Statutes, Section 1512, and therefore cause him to be subject to the restrictions of the Gaming Act at 4 Pennsylvania Consolidated Statutes, Section 1512. In support of the request, Attorney Alfano has submitted copies of letters from counsel for the Turnpike Commission and the authorities, which state the following. While the Gaming Control Board might hold an Easy Pass account now or in the future, the Pennsylvania Turnpike does not otherwise receive a distribution of revenue under the Gaming Act. 2, the authorities do not receive distributions of revenue under the Gaming Act. And 3, the Pennsylvania Turnpike Commissioners and the board members of the authorities do not have discretion to influence or affect the outcome of an action or decision under the Gaming Act and are not involved in the development of regulation or policy relating to a licensed entity or other matters contemplated by the Gaming Act. Mr. Alfano also notes that the list published by this commission pursuant to Section 1512 of the Gaming Act does not include any of Mr. Dion's aforesaid 3 positions. Mr. Chair, at this point, I would suggest that it would be an appropriate time for any interested party to speak on this matter.
Good morning, thank you. My name is Gaten Alfano, I am the requester, and we have submitted a brief dated January 28th, and with the Commission's permission, we will rest on the arguments that are in our brief, and at the risk of injecting yet another Italian name into this matter, I'd like to introduce my colleague, Attorney Leslie Mariotti, who actually is responsible for doing all the work. Thank you.
Excuse me, sir, could you please spell her last name for me for the record?
Sure, it's M-A-R-I-O-T-T-I.
Thank you.
Thank you.
Do any commissioner have any questions of Mr. Alfano or his associate? Please proceed.
Mr. Chairman, I have reviewed the facts and the relevant statutory provisions, and none of the 5 numbered paragraphs of the Gaming Act's definition of the term public official would apply to Mr. Dion. Paragraphs 1 and 2 of the definition would not apply to Mr. Dion because they list particular public positions that Mr. Dion does not hold. Paragraphs 3 and 4 of the definition would not apply to Mr. Dion because based upon the submitted facts, none of the bodies on which Mr. Dion serves directly receives a distribution of revenue under the Gaming Act. And in this regard, I would note that it is also my view that receiving payments for Easy Passes would not constitute directly receiving a distribution of revenue under the Gaming Act for purposes of this Commission's duties under Section 1512 of the Gaming Act. Finally, paragraph 5 of the definition would not apply to Mr. Dion because based upon the submitted facts, the Pennsylvania Turnpike Commissioners and the board members of the authorities are not involved in development of regulation or policy relating to a licensed entity or other matters under the Gaming Act. Given my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, the service of Pasquale T. Dion Sr. as a Pennsylvania Turnpike Commissioner and board member of SEPTA and the Bucks County Industrial Development Authority would not bring him within the definition of the term public official as set forth in section 1512 of the Gaming Act, and therefore would not cause him to be subject to the restrictions of section 1512 of the Gaming Act.
Okay, you've heard the motion by Commissioner Corrigan. Is there a second?
Second.
Any questions or comments? I have one question. Is the definition of public official different in the Ethics Act than the Gaming Act?
Yes.
It is vastly different.
Pardon me?
It's vastly different, and in fact, I would recommend that your opinion, maybe just note that you're not addressing the question under the Ethics Act. It's clear that Turnpike Commissioners and members of these authorities are public officials as the Ethics Act defines that term. So it's apples and oranges, two different laws, two different definitions.
Okay. Okay. Any other questions or comments? If not, you've heard the motion. All those in favor say aye.
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 Any opposed? Motion adopted.
Thank you. Thank you for your time.
Thank you. Okay, moving right along, item number 7 on your agenda, civil penalty orders. Commissioner Bergen, I believe you've been assigned those.
I have, thank you. There is one administrative penalty case with a proposed consent agreement for consideration. The respondent is Catapult Learning. Catapult Learning is a principal that failed to timely file a quarterly expense report for the second quarter of 2013. Parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. The respondent has already filed its delinquent expense report and paid the agreed upon administrative penalty. Based upon my review of the facts, I am of the opinion that the consent agreement sets forth the proper disposition for this case, and I would like to make the following motion. I move that this commission approve the consent agreement submitted by Catapult Learning and the investigative decision, and impose an administrative penalty in the amount of $2,730 for the respondent's delinquent expense report for the second quarter of 2013.
Thank you. You've heard the motion. Is there a second?
Second.
Thank you. Any questions, comments? If not, all those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Number 8, civil penalties default. Commissioner Bergen.
Yes, there is one default administrative penalty case for our consideration. The respondent is Aspire Academy. Aspire Academy is a registered principal that failed to file quarterly expense report for the second quarter of 2013. It is my view that the respondent's transgression of the lobbying law was negligent. Respondent has already filed its delinquent expense report but has not yet paid an administrative penalty. There is no basis in the record for imposing less than a maximum civil penalty against respondent. Based upon my review of the facts, I would like to make the following motion. I move that this commission levy the maximum administrative penalty against Aspire Academy in the amount of $50 per day for the 77 days its second quarter 2013 expense report remained delinquent, for a total administrative penalty in the amount of $3,850. I further move that the Aspire Academy be ordered to pay the aforesaid administrative penalty by no later than the 30th day after the mailing date of this commission's order.
Thank you. Is there a second to the motion?
Second.
Okay, it's been moved in second. Any questions or comments? A quick question, that money goes not in our budget.
No, it goes in the general fund.
I always, at least I try. Okay. Any other questions or comments? All those in favor, please say aye.
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 Any opposed? Motion adopted. Thank you, Commissioner Bergen. Okay, administrative matters, payment schedule, Rob, is that?
There are no.
Pardon me?
There are no payments.
Okay. All right, number 10 is posting issue And let me just remind you and give you a little background. This idea of posting came up during the interview process for our new executive director. It was proposed as a way for the commission to operate more efficiently and also to save money. At our last commission meeting in Bedford, we discussed it at length, and it was agreed at that time that Commissioner Lewis and Brian Jasonson and Robin Hitty would come up with a recommendation. If you recall, I said, I want to dispose of this. Either we're going to do something about this, I don't want to keep moving, having this on future agendas. So we received a handout today, and Judge Lewis, are you going to speak on this assignment, or do you want the staff?
I would prefer that the staff speak on it, and then I can add if there's anything needed.
Brian?
Thank you, Mr. Bolger. Commission members, we did exactly as Mr. Bolger directed, and we reviewed the matter and also the regulations of the commission most significantly, as well as the Ethics Act. And it has been determined that there is no legal authority for us to actually serve by posting. Service can be effectuated a number of different ways, one of which, though, per the regulations, is not through posting of property. What we have done is that we've come up with what I believe is not a compromise, but a different route to get to the same destination. What we have done through the investigative division historically has sent a first warning notice letter by U.S. mail first class. We have then followed that with a second warning notice where we have not received compliance. Those second warning notices have been served by certified mail. In instances where the certified mail was either unclaimed or non-deliverable, we would then initiate steps to try to get a better address. And then we would reserve by certified mail, or we would conduct personal service. We'd effectuate personal service where a commission staff member would actually personally hand a copy of the documents to the individual. That's where we came up with the idea of service by posting. We've had numerous instances in the past where someone was attempting to avoid service. We've had investigators go to someone's door, knock on the door, the person will look out the window, close the window and not answer the door. They were home. We had no ability to leave the documents at their doorstep. So then we would sit and wait in a car. We would try to wait outside their place of employment, and we would spend an awful lot of man hours as well as money trying to effectuate service. Our thought process was, if we could serve by posting, that would eliminate the time and the man hours as well as the expense. Per the regulations, we are allowed to serve by first-class mail with an attached certificate of service. A certificate of service is actually where you have the United States Postal Service stamp a separate document indicating that the documents enclosed have been handed to a member and a representative of the United States Postal Service, and they are verifying that that document was mailed and it is presumed delivered by the United States Postal Service. I believe it's maybe 90 cents or $1.80, or it's very inexpensive as compared to a certified mailing. Once that is mailed, it cannot be unclaimed because it's delivered in a person's mailbox. So the person will receive the documents that we are sending to them. The concern that we have had with the investigative division was always a due process and an identity issue. Just because you put something in the mail, we want to make sure that it's getting to the right John Smith in Philadelphia or Frank Brown in Pittsburgh. So that's what we wanted to do with the posting, is provide notice that, hey, do we have the right person, because we've now stuck this on your door or what have you. When you would serve by certified mail, someone would have to sign for it, and if the signature matches the addressee, more likely than not you got the right person. What we have determined is, and what we're proposing through the policy change, is that we will we will provide a first warning notice by first class mail, as we have always done. We will provide a second notice through certified mail in those instances where we have not received compliance. If those documents come back either unclaimed or undeliverable, through certified mail. We will still engage in an effort to try to get a better address. And we will then serve those documents through first-class mail with a certificate of mailing. Simultaneously, we will also provide notice to the individual, not service, but provide notice to the individual at their residence by placing either a door hanger or some other method of providing those documents on a brightly colored piece of paper to that person. So at the very least, they've received it through the mail, which satisfies our service requirements, and they have also received it hanging on their door. The door hanger does not constitute service. It's simply a prophylactic, double, you've got notice that the Ethics Commission is trying to find you, the Ethics Commission has served you, and you need to comply with the documents that are being provided to you. We've contacted Indiana County Sheriff's Department. I have some friends there, and I spoke with their chief out there, a gentleman by the name of Dennis Porter, and I asked him, what are their policies and procedures in regards to posting a property? He said it's kind of common sense. You take a roll of, they use blue painter's tape, tape it to someone's door. He said what they also do, and this is where we came up with the idea of maybe you doing a door hanger, kind of like when you get an advertisement on your door from maybe a pizza shop or something where they stick the little thing on the doorknob. The Sheriff's Department in Indiana County pre-prints thousands of these brightly colored door hangers that say, we are trying to contact you on an official matter. It's very important that you get in touch with the Sheriff's Department. And by doing that, you don't tape it on someone's door. You can put 3 or 4 of them on every, one on every door that someone may have. Some people may not normally use their front door. They may use a back door or a side door. One of our investigators could easily hang these door hangers on every one of their doors and then affix by stapling a copy of the documents that have already been served through first-class mail to that door hanger, again, just to provide additional notice. What this will do is it will satisfy our concern and our request with service by posting because, one, we will effectuate service in accord with the regulations of the Commission through first-class mail with a certificate of service. And two, by providing notice at the property, we will be ensured that the right person got that we have the right person that we're trying to provide service with. Because if someone gets something on their door hanger, on a door hanger that says the Ethics Commission is trying to get in contact with you, that person should be responsible enough to telephone us. And if it's not the right person, it's presumed that someone would be calling as well saying, you have the wrong person here, there's a mistake, I'm the wrong Frank Brown you're trying to get in touch with. So we believe that through utilizing the existing regulations of the Commission, we can meet our goal of getting these people served who are otherwise avoiding service, and also provide them with notice so there's no question that they didn't receive the documents that were sent to them. And that's reflected in the proposed policy. We believe it will be a cost savings, definitely, and it will also be a time saving and manpower save as well for the investigative division.
Council Vitti?
Yeah, thank you. I would just add that, just for the benefit of anyone who's not familiar with statements of financial interest, that these are public proceedings, public documents. It's not proposing to do this for investigative matters where documents are confidential. So it's strictly things that are already publicly available. Also, that if a property's posted no trespassing, our investigators will have the common sense to not go and go on the property. But having worked with the judge and Brian on this, I think this is an excellent solution.
And it meets our regulations.
It does.
Mr. Carter?
Yeah, and just to reemphasize, there'll be no more attempts at in personam service and no more of our employees sitting in cars for hours.
What would more than likely happen is when someone would go to put the door hanger on the door, I presume that they would, or we would instruct our investigators to ring the doorbell, knock on the door. If someone would answer, they could certainly effectuate service that way.
Yeah.
But if no one answers, or if we get the instance where someone's looking out the window without answering, then we would just affix the door hanger. They've already been served through first-class mail.
Okay.
So we still will be traveling to their residence,
Yeah.
but we're not gonna be standing there for 10 hours. It's
Sitting
gonna
in
be
the car and waiting.
correct. It would be a quick, ring the doorbell, no response, door hanger, they've already been served through first-class mail.
Great idea.
Yes,
Chairman Bolger, in terms of working with Jason and Robin on this, and it was very enlightening, because we do find that the primary objective of the staff, and bodes well for the commission as well, is to affect service and to make sure that people are aware and given an opportunity to correct any deficiency in filing and to respond to an inquiry from the commission timely. And the first notice goes out, as you know, and says 20 days, you get in touch with us, and there's not going to be any further proceedings initiated. And the staff, through my working with them, has indicated that first notice that goes out, you get an 80% response, positive response. So we're really narrowing the number of people, and then there's an effort through certified mail with an effort to really make sure you contact people, and a number of people respond to that, and then you've whittled the group down even smaller, and then the staff takes even additional effort to make sure that they've got a good address, searching a number of different databases, and then having done that, still complying with the applicable regulations that permits the type of service by United States Mail, but also making sure that the person has noticed by posting this, but addressing that issue of someone having to sit outside in cars and the number of man hours and the amount of the cost to doing that. And to the extent, as we discussed, and you raised the point also, is that if you are somewhere and there's a meeting or someplace else and you can in fact affect personal service by handing it to the person, that's permissible under the regulations as well. They can do that, but that concern about cost and time and use of manpower, sitting on cars, chasing people, and the like, is obviated. But again, this number is a very small number, and I think it reflects well on the staff that they've gone through every reasonable effort to make sure to affect service in accord with our regulations and to give notice and an opportunity for someone to respond and meet their responsibility, or otherwise respond while they're not required to do so.
Okay, good job. Council, does that require a motion?
It does.
Okay. Judge Lewis, since you worked on this project, would you be so inclined to make that motion?
Yes. The staff, having developed a policy and process for complying with our regulations, commission regulations, to affect service in accord with the regulations, and in addition thereto, under certain circumstances, to also post the property. Attached for your consideration is Pennsylvania State Ethics Commission Policy 1-2014. Would you want me to read the policy?
No.
Okay, the policy is attached, and I would recommend, and the policy has been outlined by Mr. Jason, I would recommend the commission's approval of the policy.
For Commissioners Bergen and Caulfield, this was a handout we received today, so you don't have it.
Okay.
Okay, you've heard the motion. Is there a second?
Second.
Second by Commissioner Corrigan. Any more questions or comments? If not, I'm glad we finally got this resolved. I think it's a good resolution of what we hope will save some money and time for our investigators. Any other questions or comments? If not, all those in favor, please say aye.
Aye.
Any opposed? We're going to post. Okay. Last item on the agenda is, under our regulations, we have to announce at this meeting that at the next public meeting, there'll be election of officers. So that's for your information. And then the next meeting has not been scheduled, but in talking to Executive Director Crusoe, probably we'll need one in April.
That's correct.
Is that accurate?
Yes.
So we're talking about April, and we'll get back to you on that. Does anyone in the public have any questions or comments they'd like to comment? Any other commissioners, staff, any questions, comments?
No?
Commission meeting is adjourned. Thank you all very much.
Thank you.